Good morning, everybody, and thank you for joining us. My name is Ken Director. I'm the chair of the Community Association practice here at Becker, and I am fortunate and delighted to be joined by my colleague, former fellow shareholder Jamie Duchovna, whose practice focuses on labor and employment. And that is the topic for the day. And this is an important topic for associations because it can be a very litigious area. It can be a minefield for your boards, and it can also be triggered by certain activities that your owners may engage in. So I want to jump right into it. Jamie, good morning. Welcome. Thank you for joining us.
Hi, Ken. Good morning.
First of all, can you explain what I mean when I say employee as opposed to other people who may be working on the property?
Yeah, so one of the prevailing definitions of what is an employee is any individual that an employer suffers or permits to work. And so if you have somebody that you've engaged to do work on your behalf, and it's defined very broadly, that's generally going to be considered an employee. An independent contractor is obviously different, and we're going to talk about that when we get into some of the legal trends and some of the hot button issues that I know you see over and over again in the association world.
So to be clear, if the association has a tree trimming service, the employees who come on the property for the tree trimming service, they are or are not considered employees?
Typically, they're not employees of the association. Usually, and the easiest way to think about it is business doing business with another business. So if you, association, engage tree trimming company to do business at the association, they then bring employees to come onto the property that then perform tree trimming services. They leave and they continue their business. They go into other communities, other developments, and do their work there. It is a business doing business with another business.
Okay. You mentioned legal trends affecting associations as workplaces. Can you tell us what some of those are, please?
Yeah, so recently, and I mean really recently, October 11th of this year, we saw a proposed rule that came out of the Department of Labor. So typically we see in employment land, whenever we get a new administration, this, for whatever reason, I don't really get it, but it's one of the issues that we see. Old administration goes out, we usually have a rule under that administration, new administration comes in, sometimes we go back to one we've had before. And so recently what we've seen is a shift away from the Trump era rule. The Trump era rule, as you can imagine, was very pro-business and really designed to streamline what is an independent contractor versus an employee. And the test was really focused on two things. One was, does the individual have the ability to see profit? In other words, are they in the business for themselves? Can they earn $1 million a year versus $1,000 a year? And if they have the ability to see profit and loss, that was one of the factors. And then the second factor was just degree of control. You know, do I have control over the work that I'm doing? And so under Trump, you were really looking at just those two issues and really nothing else. And like I said, it was designed so you weren't really bogged down, if you will, into these other factors that we are now seeing a shift back to, which I know, Ken, you've been doing this a long time and you've probably heard about this. This was under Obama, we had this test. So we're really shifting back to what we had under Obama, which is a 6-factor test that looks at other types of things, not just does the individual have the ability to see profit and loss, does the individual have control over what he or she does. We now have additional factors that are being considered. Like, for example, does the individual buy his or her own tools, or is that something that you provide on their behalf? Is the individual an integral part of your business? You know, do you need them in order to do your business?
So we're going back to the more traditional earmarks of what constitutes an independent contractor.
Correct.
So for the associations, it would be accurate to say that if you hire a management company, they are an independent contractor. If you hire a lawn care service, they are an independent contractor. If you hire an engineer who has his own engineering firm or her engineering firm, or is a separate professional, they are an independent contractor because they're not, I guess an easy rule of thumb would be if they're not on your payroll, there's a pretty good chance they're an independent contractor.
Yeah, no, absolutely. And it's, one of the things that these tests are designed to sort of figure out is the economic reality of the situation. Are the individuals economically dependent on you or not? And so, for example, an employee, somebody who comes to work every day, clocks in, clocks out, is under your control, they're
Right.
completely economically dependent on you. You don't even really engage in that analysis, but where we see the issues come up time and time again is that gray space where if you're checking the box on the independent contractor side, you've got some boxes checked there, but then you also have some boxes checked on the employee side. And that's where, we see the problems that come up time and time again, because it kind of looks like an independent contractor, but also kind of looks like an employee. And that's where a lot of the confusion comes up. And that's where you see lawsuits over misclassification come up that can be very problematic for associations.
I want to move to another topical issue. A lot of associations do drug testing.
Yes.
And with the advent of medical marijuana as treatment for people who suffer from certain disabilities, how does that interplay with an association that wants to operate a drug-free workplace?
Yeah, so the state of Florida has not extended protections in the workforce. So while you have medical marijuana as permissible under the state, and you can certainly get a card and you can be prescribed medical marijuana in the state of Florida, because you happen to use medical marijuana, it doesn't afford you additional protections. So this has become a bigger issue, as you can imagine, because on the one hand, you have the state of Florida that says, well, if you use medical marijuana, you don't necessarily have protection in the work world if you're using it, but you're allowed to use it, so again, and this is, why we litigate these issues, because there's confusion over it. It's like, well, wait a minute, how do I reconcile one with the other, especially when we know that we can have a drug-free workplace policy, and that gives us discounts on our insurance, and at the same time allow somebody who uses medical marijuana to either remain employed or to be hired in the first place. And then it presents additional issues. For example, if there's an injury in the workplace, and so those are some of the issues and where you see it come up. And while it may be permissible for them to use medical marijuana, they may test positive, for example, obviously they're not allowed to come to work impaired. And so if they're required to, or they do use medical marijuana, most employers who are willing to make that accommodation, so if they want to, they can, there's still some, rules, if you will. It's not this unfettered, just because you use it, you can now use it while you're engaged to work. And that's usually not so.
How does an employer determine whether or not you're impaired? That's almost a rhetorical question, but it seems like an impossible burden for an employer who wants to operate a drug-free workplace. If you have an employee who is impaired, who's on the roof cleaning the gutters, you're taking a huge risk.
Yeah, no, and so it's interesting because what I've seen are really just two divergent paths when it comes to medical marijuana. So on the one hand, we have clients that have real hiring problems, which we'll talk about in a minute. And so for them, they've always in the past said, I'm going to drug test. If you test positive, it automatically disqualifies you for employment. I've had clients that have shifted away where they test really for everything but marijuana. And then you have this other camp that says, listen, if you test positive, I don't have to offer you a job. And so if you test positive, I'm not even going to hire you in the first place. And I think it really matters for the position that you're hiring for. So for example, if you have an employee that does dangerous work, uses heavy equipment or materials, more maintenance type stuff, the analysis is going to be a little different than somebody who's working in the office, where you may say, well, I don't know, the risk may not be so great. As long as we have rules that say, again, you can't come to work impaired, but, then it sort of begs that question, like you said, Ken, how do you know the person?
Sounds like a difficult balance, because on the one hand, you can allow these people to work there and c'est la vie. Number two, you can allow them to work there, but try to make a determination as to whether or not they're impaired, or whether or not the job that they do is sufficiently dangerous that it's not advisable for them to work there if they're using marijuana. Or number three, just simply say you can't work here if you test positive.
Yeah, and it's, there's no one size fits all. Every employer needs to make decisions what's best for their business. In a community, you have to decide what's best for your community. I mean, sometimes it's easier to tell when someone is impaired, if they're slurring their words, they're falling asleep. I mean, there's some things that are more telltale signs, not necessarily that they are under the influence, but maybe more apparent. Sometimes where you find out that they're under the influence is because you test after a work-related injury, and lo and behold, they test positive. But it could be that they're testing positive because the night before they showed up at work, they smoked some marijuana.
Yeah. I want to talk about hiring and how that works in Florida for associations, what the process ought to be, and what it means to hire an employee.
Yeah, so good news is it's pretty easy to hire somebody. There's nothing magical about it. It's just you engage the individual. But what is unusual about where we are today is it is a very strange market. We've seen things that I haven't seen really in over 20 years of practice. You usually don't have clients come to you and tell you they're afraid to terminate people because they're afraid they can't find somebody to replace them with. And that has been a very real issue for a lot of our clients, because filling a lot of these positions like maintenance, housekeeping, office staff has been extraordinarily difficult. On some hand, we wonder, it's like, where did everybody go? And I don't know where everybody went, but I know that it's become a lot harder to hire, and the workplace has changed a lot, and there are a lot of other opportunities for gig work and for hybrid work. And so if you don't offer those things as an employer that incentivize people to want to be engaged, it makes it a little bit more difficult to find the people to engage to do the work.
There are interesting generational changes as, the baby boomers come out, the millennials come in. There are certain changes. Florida is described as an at-will state. What does that mean?
So at will means that either the employee or the employer at any time can end the relationship for any lawful reason. So it gives both parties the right to walk away. Actually, all 50 states are at will, and Florida is really no different in that regard.
You said lawfully terminate.
Yeah. What
are some of the exceptions to the quotes unfettered right to terminate an employee's job with an association? What are some of the exceptions?
Yeah. So we'll talk about this in a little bit, but when you have an employee that has a contract, it's a little different, because while you can have a contract in place that says the individual is employed at will.
I'm going to get to that next.
Yeah, what a lot of times we see is that a person's engaged for a period of time. And so we can't just say, okay, you want to terminate, hey, no problem, no big deal. And while, yes, maybe in theory it's not a big deal, but if you have a contract in place, you got to terminate the contract in accordance with the terms of the contract. At will, a little different. So you don't have the impediment of an agreement that you have to go back and look at. But the thing that's different is, let's say, for example, and this is an issue I see all the time, it comes up again and again and again, where you have, so for example, you have an employee that comes to you and complains about their pay. I worked overtime, but I didn't see it on my paycheck, and I'm concerned that I'm not getting paid my overtime. and maybe they come to you and they come to you 3-4 times. You're like, well, that's, a little annoying. I don't really like them. They, are, a team player, and maybe they do something in the between time that would maybe want you to terminate them. But, you can't retaliate against somebody. And so while you may be terminating them for completely lawful reasons or no reason at all, because remember, it's at will and we can do that, you have to be careful, because if you're terminating them in retaliation, even if that's not what you're doing, if there's a perception because of timing that, hey, listen, I just complained to you last week about my pay and not seeing my overtime, and then this week I'm getting fired. Well, it seems to me that the two are connected. So you can certainly terminate somebody at will, and if they violate a policy, absolutely, but you can't terminate them just because they've complained. That's considered retaliation.
We live in a society where a lot of employers are actually, and I said employers, are actually afraid to terminate because there's just it's such a litigious area. But it's important to understand that an employee acts in a representative, in an agency capacity for the association. So if you have an employee, we've just had this discussion with regard to medical marijuana. If you have an employee who engages in dangerous practices, if you have an employee who you believe may be entering units and stealing, if you have an employee who engages in threats or violence directed at other staff or residents of the community, we can talk about good cause, but the association has an obligation to protect the person and property of the owners. So you've got to be prepared to remove someone who is creating potential liability for the association as well.
No,
so
absolutely.
It is a double-edged sword. We've talked about the unfettered right to terminate and some of the exceptions to it. And you mentioned employment contracts. What is the importance? Is it important to have an employment contract? And if so, why?
So one of the nice things about employment contracts, it's kind of in the same vein as an employee handbook, which we'll talk about, but it really sets forth the expectations going in.
A job description.
Yeah, like what exactly, what is expected of me if you engage me. So typically one of the things you see in a contract is a section sometimes referred to as job duties, or even like a job description. It's a little different, but essentially it says, if I engage you, this is what you're going to be doing for me. So the person knows on the front end, at a minimum, what most of the expectations are if they are engaged. It also talks about how the relationship ends. And so if there's an expectation on the one side that they be given notice, they contract for that. So that is something that's usually a term that you see in there. Not every contract's the same. Some contracts have what I call standard terms. Usually you have a duration, right? A term, 1 year, 2 years. Sometimes they automatically renew, sometimes they don't. But a lot of times both sides want the contract because on some level it offers something good for both sides. There's protection for the employer that if I engage, for example, property managers, where you routinely see it over and over and over again, a written contract. The property manager wants to know that if he or she is engaged, they're going to be there usually for a certain period of time. And same thing with the board that's looking to engage the property manager. They want to know that, hey, listen, if you don't like it here, that's fine. We recognize that this community may not be a good fit for you. But if that happens, we need time to find somebody. So, there's usually this, duality of give and take, obviously, how much you're charging, and how much the person's going to get paid. That's a term that you routinely see. But then there's others that aren't so routine, and it really just depends on your community whether this is something that makes sense, like exclusivity in the contract, things like non-compete, non-solicitation. You don't really see it all the time. You usually see it more management companies that have the non-competes with the associations, but I've had association clients that are very concerned about not so much the non-compete aspect of it, but more non-solicitation,
What is a
Yeah.
non-solicitation clause?
So non-solicitation clause in its most basic sense is you can't do anything to take any of our employees. Sometimes with managers, the concern is that they bring people maybe that they knew at a different community, but then if everything is working well with those employees at the association, they don't want to lose them if the manager leaves. And so there's a non-solicitation provision, which usually says for a period of time, you agree you're not going to do anything to interfere with my employment relationship with these other employees.
This is a very important point for the people listening, because when you hire a management company, oftentimes they staff your property. Sometimes they pick up your existing staff and put them on the management company's payroll. It is important when you're entering into that contract that you protect your existing employees from a non-solicitation clause, because they were your employees before the management company got there. And if things don't work out with the management company, you might want to keep them since they were yours initially. Also, the terms under which you can buy out the non-solicitation clause, because that's often the way these things are resolved, they need to be defined with some clarity. Again, this is most important with management company contracts because they may have non-competes with their individual managers that they employ, but it's the non-solicitation clause that impacts the association's ability to say, we really like these people that the management company put here, but we don't want to have a management company anymore. And that's where you really need to protect yourselves at the contractual point. I want to sort of segue slightly. Can you explain what is the difference between an employment contract and having an employee manual or employee handbook?
Yeah, so they serve different purposes. The contract's really to engage the individual, to set out the terms. I mean, typically they are done, not really and I use this just generically, like a rank and file employee, typically in an association where you see a contract, it's usually with a property manager. And then most other employees who are engaged, maybe an assistant general manager, you may see a written agreement as well, but usually everybody else that is hired is just hired at will. So the employee handbook is really designed to set a level of expectation, to let people know when you're employed by them, what our expectations are in terms of policy. For example,
I think you just said the key word. My understanding has always been that the manual is an articulation of the policies of the employer. A sexual harassment policy, a drug-free workplace policy. It's the operating manual for the owner. It's not a substitute for having an employment contract where you want to set forth specific terms with an employee. I mean, you can have guidelines for saying, the maintenance workers are supposed to work from 8 to 4. Office staff is there from 9 to 5:30, what have you. But and would you say that it's important to have both, particularly if you have a significant workforce?
Absolutely. I mean, each association needs to decide what's best for them. I mean, as far as an employee manual or an employee handbook, I mean, I think years ago you once said if you have one employee, you should have an employee handbook. But at a minimum, if you're treading around 10 to 15, you should absolutely have one. They're really, meant to be living, breathing, kind of like the Constitution, and meant to evolve over time because laws change over time. Your expectations change over time. There's usually certain policies. And to answer your question, an employment contract is not a substitute for a manual. They do different things. An employment manual or employment handbook is really designed to cover everybody, regardless of whether you have a contract.
Can an employment manual, an employee handbook, protect the association in the event of a dispute with a current or former employee? And can you give us an example?
I know, 100%. So actually, the most important one that you see is with sexual harassment. So, or any kind of harassment. If you have a policy in place that says, for example, if you believe that you've been harassed, you have an obligation to bring it to our attention. The law says, for example, if it's two coworkers that have an issue, the employer can say, listen, how am I supposed to know if there's this issue with 2 employees if it doesn't come to my attention? So if you're an employer, you have a process in place for dealing with these kinds of complaints. And if you are an employee and you do not avail yourself to the process, you allow the employer to then raise as a defense if there's ever a lawsuit that gets brought. It typically starts with an EEOC claim. If that claim is initiated and the person hasn't availed himself or herself to the process, the association employer gets to say, hey, wait a minute, I didn't even know about this because nobody complained to me. We had no idea that this was going on. It's not like it was a manager and an employee where knowledge is imputed because you're dealing with management or executive level. And so it really protects you if you have a process in place, and especially if you have an employee that doesn't avail him or herself to the process, you get to then say, hey, wait a minute, you also, employee, had an obligation. It's not just about us. What did you do to make sure we knew? Because if we knew, by the way, we would have done something about it. So you can't expect us to do something about it if we don't know about it in the first place.
So the employee handbook isn't just about policies, it's also to set forth processes to address employee concerns. I want to segue, take a moment and address some of the questions that have been raised.
Okay.
One of the first questions that came in was whether or not an employment contract is a record that is accessible to owners for inspection. Now, under the laws, contracts to which the association is a party are official records. But one of the categories of records that is exempt from the inspection rights of all the owners is personnel records. Do you consider an employment contract a personnel record?
So for my purposes in employment land, I do. Employment records are pretty expansive under just not when you're looking at 718 or 720, which may have a more narrow definition of it, but typically what they're going to go back and look at is, well, what does the employment law say about it? And the employment laws are a little more expansive, and it's not, like any little thing is an employment record or personnel record, but most things are, so if you have a contract, that would be a personnel record. If you have discipline.
You would think it would be an easy question, but the reality is, in your world of labor and employment, what constitutes a personnel record is drafted broadly to protect the employee. Right. In the condo and co-op world, what constitutes an accessible official record that is subject to owner inspection is always viewed as broadly as possible. What typically happens with people wanting to see employment contracts is they just want to know what people are paid. Yeah. And those are financial records which are in fact accessible to unit owner inspection. But this is an interesting question, and it seems like a simple one, but the answer is not that simple, because in the employment world, there's one perspective on what constitutes a personnel record, but in the community association world, there's a different perspective on a unit owner's right to access and inspect records. One of the other questions was, you mentioned gray areas with regard to employee versus independent contractor, and that's a tough question to answer, but let me take a stab at it.
Okay.
Typically, under the case law, what constitutes an independent contractor has like 10 different criteria. Do they buy their own tools? Do they control their own schedule? Do they control their own work? And there are a host of other issues. Does the association provide benefits? Do they have a desk or an office at the association place of business? And the gray area is that you may have a situation where some of the indicia of being an independent contractor are met, but others are not. So it really is a question of looking at it on a case-by-case basis to determine whether or not the relationship has been sufficiently set up as an independent contractor relationship, if that's what you're going for. Is that a fair assessment of the issue?
Yeah, absolutely. And I think one of the things for me that I see the most often, and I'm sure you do too, is you have this particular position, for example, that you can be a property manager and be an independent contractor property manager, where you sort of have your own business, you manage multiple properties. you go to a particular association, maybe Monday, Tuesday, and then other buildings of different days of the week. But you can also have a property manager who's an employee. And so when you have the same individual that performs almost the exact same functions for you, but one is an independent contractor, but the other is an employee, what you're looking at is like that indicia that you were talking about. Well, what do I see over here versus what do I see over here? Why is one this way and another is defined as something else?
Let me give you a different example, Jamie, and I'd like everybody to hear your thoughts on this. The association allows, doesn't hire, but allows a yoga instructor to come in and have people pay to participate in a class out on the lawn by the pool.
Yeah. So
the association would want this person to be an independent contractor, so they have to get their own health insurance, their own liability insurance. How would you structure that relationship to protect the association from having this person treated as an employee?
yeah, so it's a great example, Ken, and that's one of the ones I routinely see, especially in clubs, with country club clients. They have these issues that come up all the time. So for me, the first thing inevitably that you want is a contract. You want a written contract with this individual that talks about, one, what this relationship is and what it isn't. So
that identifies them as an independent contractor, not as
yeah. And that isn't going to be the be all end all. It's not like, for example, court will say, oh, look, you have this contract, and so that's all that matters. But it's a step, that is the first step of what you want to see. What does it say in writing? What does it say about the relationship? Because I know, and any contract, it clearly says, when you're engaging a yoga instructor that's an independent contractor, you are an independent contractor. There's no employment relationship. You understand that.
But it's important that the instructor provide proof that he or she carries his or her own liability insurance, his or her own health insurance. These are all things that help to establish that this is not an employee.
Absolutely. And where clients kind of run afoul is when they're like, well, what if we give them 2 weeks vacation? And that's one of the things I'm like, what do you mean give them 2 weeks vacation? Why would you give an independent contractor 2 weeks vacation?
Yeah.
They're not your employee. That's a benefit. Why would you do that? And sometimes clients really just don't know. If the yoga instructor wants to take a month off, he or she can, but that just means, somebody has to fill in under the contract if you have that individual page. Yes,
There's
no
class.
Right.
A lot of communities simply allow this to happen without documenting the relationship. And if you have a community, particularly a community of elderly people, if you don't document this properly, particularly say with a yoga class or a water aerobics class. I had one where they were teaching a class where you were suspended 4 feet off the ground in straps to do like aerial yoga. You need to protect the association from the potential liability that may arise if the instructor or anyone who participates in the class gets hurt.
Yeah, no, absolutely. No, you definitely want that. With independent contractors, that's another thing to me. In addition to wanting a contract in place, you also want to make sure that they have proper insurance to protect the association. If they get injured on the job, for example, do they carry workers' comp insurance? They can get a waiver if they don't have 4 or more full or part-time employees. You can still get workers' comp insurance, even if you're not required to have it under Florida law. So, those are the kinds of things that associations should be concerned about. Well, what happens in the event that something goes wrong? How are we protected? We know we have our own insurance, but why should our insurance cover them? They're a separate business.
You raise a good point that requires some emphasis for the people listening, which is workers' comp. If you allow people to work on your property who don't carry workers' comp, it can affect your workers' comp premium when your carrier at the end of the year does a reconciliation.
Yeah, no, absolutely. I mean, workers' comp, what's so great about it, most people just don't think about it this way, but at its core, it's tort immunity. It protects you from a negligence lawsuit, because negligence, those are just accidents, things that aren't happening purposefully, and it's designed to give you protection in that if you have a work-related injury, for example, the person can't sue you for negligence. They can't say, well, you didn't do this, this, and this, and because you didn't do that, you breached your duty to me. It just covers them in the event they have a workplace injury or an occupational disease, and it gives them pay, a percentage of their pay, and then it also gives them, benefits to fix the problem, if they need to go for surgery or physical therapy or anything like that, so there's a limitation on what the employee can get if there's an injury. And then the flip side is, if as an employer, you kind of know what you're looking at. It's not, I'm getting sued for negligence and, the pie's the sky, in terms of what they can ask from me because I didn't have that insurance to protect me in the event that there's an accident.
It's important as an employer to remember there's a difference between what is easy and what is right. I read an article years ago addressing potential association liability, and the title of the article was "Beware the Handyman."
Oh,
Because
sure.
there are a lot of associations, maybe even have someone living there who is a handyman who says, "Oh, I can go fix the gutter. I can patch the roof. I can rewire the sprinkler system. I can rewire the electrical system. Pay me, $100 and I'll go do it." Guaranteed that person does not have insurance, guaranteed that person does not have workers' comp, and guaranteed that person's medical insurance will not cover them for injuries that are suffered if they're doing something on the job. One of the nightmare scenarios I faced years ago was people came back from being out of town for the summer, and one of the association employees, as a service that was not a required service from the association, went to the unit to light the boiler for their water heater. And of course, as fate would have it, boom. And the liability carrier wouldn't cover it because they said it was workers' comp, and the workers' comp carrier wouldn't cover it because they said this was something he did that was outside the course and scope of his employment. It is important to stay in your proverbial lane when it comes to the tasks that you allow your employees to engage in, whether it be for the protection of the association for adverse claims from the owners, or the protection of the employee and the association should the employee get injured or accused of some wrongful conduct. I want to segue, Jamie. And part of this, I'm sure you're going to say, is related to what you put in your employee handbook or manual. But in a lot of communities, it is unfortunate, but it is real that employees and staff members take some abuse from, whether it be from board members or owners. How do you protect them from that? And I'd like to hear, secondly, your analysis of how you would respond if a client called you and said, Mr. So-and-so was abusive or threatening to the people who work at our front desk.
Yeah, so while it may seem strange, there are protections that are afforded to employees vis-a-vis homeowners. Vendors, same thing. So as an employer, you have an obligation to make sure that not only are you not experiencing, discriminatory or harassing behavior that's among employees or between employees, you also have an obligation to prevent it if it's a vendor or if it's an owner. And so what do you do in a situation like that? And it can be really difficult to handle. I mean, and I'm sure primarily because the person lives there, they own there. So what do you do to protect your employees when this individual has a right to be there? I mean, and we've recently just dealt with an issue that's sort of been, lingering and ongoing with a client. And, sometimes you kind of have to figure out the best way because there's not necessarily a right way and a wrong way, but there are some things that you should be doing. One of the things for me sometimes that I have found effective is, confronting the person who's engaging in the bad behavior. If nobody confronts the individual about what he or she is doing.
But I want to interject right there because this is a good starting point to point out to the board members and managers listening that doing nothing is not a good option.
No.
You've allowed somebody to create a hostile workplace environment for an employee. You've made an employee afraid to be there at your property working. Doing nothing is not an option. What you do, which is what Jamie was just getting into, has to be evaluated on a case by case based upon the severity of the conduct. Somebody who makes a flippant remark while they're walking by, that's one thing. But somebody who comes to the front desk, gets in an employee's face or threatens an employee or says, I have a gun, I'll be back in a second. That's much more serious. An employee who brandishes a weapon, somebody who brandishes a weapon in a way to threaten the employees, that's a more serious thing. But I just wanted to emphasize that opening point, Jamie, which is doing nothing sends a horrible message to your employees, and it will make it difficult for you to attract and retain good people.
Well, and it also is going to be a problem if there's a lawsuit. What are you going to say? I did nothing. You know, that was between them. You know, it was an owner. We didn't feel that we had a right to do something. I mean, especially if something's more serious, and you can believe if there's a lawsuit that's filed. I mean, who are they going to look to blame? Are they going to blame the homeowner? Maybe, but they're also going to blame the association for not doing something. And so it starts at that, you know, very first thing, which is confronting them. And then sometimes, you know, a conversation may be enough, but a lot of times it's not, you know, and so you have to think about, well, what are the next steps? What are we going to do to assure the employee that we're doing what we need to do? I know some people who are on, and I saw some earlier questions that people had asked, like, what is a hostile work environment? It is one of the most misunderstood terms, in my opinion, because people think if I don't like where I work, or if I have bad working conditions, like I don't like my hours, my boss isn't that nice to me when he or she talks to me, that's a hostile work environment. That's not so, not under the law. The law looks at two things, you know, it looks at severity, it looks at pervasiveness. You know, it is what is occurring in the workplace so severe that the workplace is now hostile. You see that sometimes, but where you're more likely to see it is pervasive. It's these little things over time that sort of add up, that show, listen, this isn't just sort of like what you were saying, Ken, a one-off situation. This is a situation where I'm seeing a pattern here of behavior that overall, when you look at this, sort of take a step back and big picture, it doesn't look right. There's something about this work environment that's hostile because of all of these things. When you put them together,
the aggregate,
exactly.
of the cumulative effect of the treatment. You know, one of the other ways that employees are taken advantage of is sometimes an owner thinks the association employee works for the owner, and the owner demands and expects services within the owner's unit. Come up and fix my air conditioner. Come up and set up my computer. Come up and install a light fixture for me. Come up and connect my new dishwasher. The association has a defined role in a community. There are services the association is obliged to provide under this governing statute and the governing documents, and those things are properly provided at common expense. Services provided to individual owners need to be carefully monitored and controlled. It doesn't mean that for those of you that want to provide a concierge level of service, you can't do it, but you've got to protect yourself and protect your employees. And it's got to be made clear in a written document signed by the owner that this employee is not doing this as an employee of the association. I am hiring this employee separately. I am not relying on the association for this. I am not viewing the employee as an agent. This is my employee for this task. And the document has to have a release and a hold harmless in it to protect the association if the owner comes back later and says, well, the employee was in my house and my Rolex disappeared. Or the employee was installing something and dropped a hammer and cracked my tile floor and the whole thing's got to be replaced now. You have to be very careful about documenting this, especially for those of you listening where your community wants to provide a heightened level of service to your owners, which is not a bad thing, but it's got to be handled carefully. I've had communities where the employees take the owner's cars to fill them up with gas and wash them. I've had employees where I've had associations, excuse me, where the employees use the owner's car to drive the owner to the airport and go pick them up. That was before Uber, but still. So this is another way that employees can be pulled outside their comfort zone, and you need to be very careful about how you document it. I want to say, go ahead, please.
What I was going to say is, I think for communities, from my perspective, there's no one size fits all, whether you offer concierge level or, we have clients that are the exact opposite, which say, if you work for us, you will not do work for other owners. If we catch you doing work for owners, you will be terminated. So we have, on the one hand, concierge level, what you want, we will make it happen, versus absolutely not. So that to me is not right or wrong. You have to decide what's good for your community.
But you got to protect yourself if you're going to.
Correct, exactly. So if you are concierge or sort of anywhere in between, and not the absolutely not, we're going to terminate you if you do it, you got to do it the right way. You got to make sure the associate is protected. You got to make sure the employee understands what he or she can and can't do. And then you, as the employer, need to make sure that you enforce what you put in place to protect the association. So if you have an employee that goes into a unit with their uniform on, you got to discipline them. If they, suspiciously are missing for hours on end
During the workday.
During the workday, they're stealing time. If they're doing work for owners that you haven't authorized them to do, that they're doing, is this, second job or side hustle that
they're double dipping.
They're double dipping, and you can't have that. So you have an obligation as an employer, if you allow it, to make sure that it happens in a particular way. And you got to make sure that there's protection for the association if you do.
In some communities, this practice can actually be made part of the association's functions. And you can adopt a set of guidelines, and this work can be provided through the association, which will better enable you to protect the association by getting it under your liability coverage and your workers' comp coverage. So there are a couple different ways to approach this. I want to turn you loose on maybe the most contentious issue of all. We've got about 10 minutes left, and I'm just going to let you go on this. These are the last three subjects I wanted to discuss, and I'm going to ask you to take them in the aggregate. Number one, how do we handle or address an employee whose performance has fallen below acceptable levels? Counseling, documenting, and then if it doesn't work out, how do you properly terminate? And if you do terminate, what is the value of having a severance agreement, particularly for a long-term employee?
Yeah.
That's not a mouthful there, but I'm sort of laying the whole thing on your plate to sort of walk us through.
Here we go. Feel free to jump in too. So yeah, I mean, with most employers have a progressive disciplinary policy. So what does that mean? That means that you usually have steps before you get to termination. So it usually starts with verbal, hey, I didn't like that. Some people call it a coaching, some people call it a verbal warning, reprimand, but it usually starts somewhere. Sometimes it's appropriate to start at the end, and it's just termination because you have an employee that does something that is just do not pass go, do not collect $200. What you did was really bad. You don't get any more opportunities to fix it. We don't care. You're done.
And a good example of that is an employee who does something that creates liability for the association because it's so obvious and so egregious.
Absolutely. And it's usually one of those things that most times clients don't even need to call us because they're so sure what happened is so bad that it warrants termination. There really isn't any other discussion about it. So progressive disciplinary policies are meant to, sort of be the guideline, but, it's not like you got to start in any particular place, but usually you want to see progressive discipline, especially if there's just like, for example, a lot of little things. So maybe you have a person who is routinely late to work. Or are you going to fire them because they're late to work one time? Well, listen, you can, 100% you can, no questions asked. But most employers don't terminate somebody just because they show up late to work one day and maybe they don't have an excuse. So you're going to want to start somewhere where it sort of matches whatever it is that's going on. What is appropriate to do? And then on some level, you got to think about it because in association land, most people have had jobs in the outside world. So they're kind of using this as, well, wait a minute, if I would have come in late, I probably would have at least, been written up. Well, maybe not the first time, but if I've done it 5 times, do you have that documentation in place? And to your point about documentation, I always say in employment world, documentation is the golden rule. It's not to say that if you don't document, it didn't happen. But if you ever end up in court and there is a lawsuit, a jury is going to say, well, wait a minute, you told me that this employee was bad, that he or she wasn't doing her job. Why weren't they ever written up? And to say, well, I didn't get around to it is not really a good excuse. They want to see it. They want to know. And there's a certain truthfulness to documents that are created at or around the time.
It's uncomfortable, but it's important.
Well, and to your point, one of the more important things are reviews. It's such an underutilized tool that the employer has. Employees, if you tell them that you're going to review them at the end of the year, they don't look at you sideways. That is something that happens in a lot of different places. And to say, well, it's inconvenient. I mean, Ken, I know, we have to sit down and we write reviews at the end of the year. And yes, it's time consuming and it's not one of my favorite tasks to do. But if I supervise somebody, I expect that I have to do it. And if I don't do it, the employee may not know what's working and what's really good and what's not.
You have to resist the temptation to give them all A's.
Exactly. No, that's the worst thing you can do to an employee. And I'm not saying that you need to give them all F's, but if an employee needs some work in a particular area, you need to be honest. And I think for a lot of employers and particularly managers, it's uncomfortable sometimes to tell a person, hey, listen, you do this really well, but you kind of suck at these other things. But if you don't tell them, they may live in a very different universe. I always say it's like, there's what's happening in the real world, and then there's the alternative universe.
And you need to be consistent, because if you've actually sat with an employee and counseled the employee about where the shortcomings are, and your year-end review document is rave reviews, there's nothing wrong, you've created a conflict which is going to be held against you in terms of your own credibility.
Exactly. And then, to your point about consistency, same thing with employees. You want to see consistency among employees, and especially employees that are the same. And so if you have one employee that's routinely late and another employee that reports to you that's also routinely late, same job, let's say they're both in housekeeping, they both show up late, but you discipline one and not the other. Okay, well then that's not a problem for the employee, that's a problem for the employer. You need to create consistency, and you also need to enforce your policies, and you need to do it in an even manner. So those are all things that really are important and kind of lead up, to the crescendo of the termination.
Which is where we're going to get to. So you've reached the point where your admonitions to the employee have not worked. The employee is continuing to do things that are unacceptable, maybe has even gotten worse. And we're now at the point where the board is ready to make a termination decision. Walk us through it.
Yeah, so the good news is there's not necessarily a right way and a wrong way to terminate, but there is inevitably something that should happen at that point. One, you got to let the person go. So, whether it's uncomfortable or not, and it's usually not very comfortable to tell a person that, hey, listen, this is not working out. One question I get all the time from clients is, what do I say? Do I have to tell them the reason? You don't have to give them a reason at that point when you're terminating them, but sometimes I think it's appropriate. There are people who, remember I said, live in this alternate reality. And so if you don't tell them, hey, listen, I've talked to you about 10 times about you routinely coming into work late, your interpersonal conflicts, your insubordination, and you just are not getting it right. You are not adhering to policy. You're not correcting the deficient behavior. And we have now reached a point where I see that this is not getting fixed. So sometimes it's important to tell a person. I have sometimes clients that don't want to because they don't want it to be confrontational. I have found a very effective tool is being very firm when you tell a person the reasons why, if that's what you choose to do. The decision has been made. We are not revisiting this issue. Because if you allow them, and this is why some clients don't want to give reasons, is because sometimes you engage in this volley back and forth of, I'm not a good employee. Yes, I am.
And it creates an environment where the employer could conceivably slip up and say something wrong.
100%. And one of the things that you want to do when you do terminate is have paperwork that goes in the personnel file that says why. I have never seen a client, it's not to say that it can't happen, but I personally have never had a client, and I'm sure you haven't, Ken, either, when a client calls you and tells you they want to terminate an employee, and I say, okay, why do you want to terminate them? No reason, just because. That has never happened.
No.
Right. There's always a reason why they want to terminate.
My first question is, have you met with, have you counseled, have you addressed this with the employee? One of the questions that came in is, should the employee actually sign that incident report? And it would be nice, but it's not always something that you're going to be able to get them to do.
Yeah. No, important. I mean, one of my favorite lines on one of those documents is, you're not signing it because you agree to everything in it, but you're signing it as an acknowledgement that you received it. So it gives the employee an opportunity. Listen, you may not agree what's in it, and this document says that. You don't have to agree with me, but you have to acknowledge that you.
That we had the conversation.
Exactly. And another thing that a lot of clients prefer, and I get it, you don't have to have two people in there, but sometimes there's safety in numbers, if you know what I mean. So if you have a second person in there, it's not just my word against the employee, it's now me and another board member or my assistant general manager. There's now two of us that can say, here's sort of what happened and here's what didn't happen.
Sometimes the employee uses their ability to ingratiate themselves to the owners
Yes.
to leverage the board.
Yes.
You have to remember as a board that you are there to act in the interest of the association. An employee that I may have used for the past 10 years to walk my dog or something like that, you have to put that aside as a board and make an employment decision based upon the interests of the association. Jamie, in the last minute or two that we have, a lot of times when for example, a longtime manager is leaving, even if they're not being terminated, it's by mutual agreement. The association wants to pay them some sort of severance. Or even if it's a firing, there's a sort of a mutual agreement that we're going to structure an agreement, we're going to pay you some severance, goodbye and good luck. What is the value of a severance agreement? And just give us the sort of the elevator speech version of what it should address.
I mean, the number one must have is the release. You are not required to give severance unless it's a contractual obligation that you have. And so if you give it, in my world, you get something in return. It doesn't come for free.
Right.
So if you're giving an employee severance and you're not contractually obligated to do it, or you're contractually obligated.
That's an important caveat. If you put the right to severance in the employment contract, then you don't have consideration for the release.
Right. So you got to give them something else.
You may want to say that severance may be paid at the time the employment ends, and that'll be between the association and the employee. But if you put it in the contract that you're entitled to 6 months pay, then you don't have consideration for a release.
Well, and you know how you get around that, Ken? At the time you do the contract, you attach as an exhibit to it the separation agreement that they're going to sign at the end. So, hey, yeah, I'm going to give you 1 month, 2 months, 3 months.
But you're going to have, but you're going to have to sign this document.
Because you're going to have to sign this document when you do it. So the number one thing you want is a release. If I'm giving you something, I'm getting something in return. And then there's a litany of other things you can ask for.
Non-disparagements, etc. One of the other things that I want to point out from the CA world is that if you have a former employee who has been disruptive on the property, who has come onto the property after being terminated and is disruptive or abusive or engages in behavior that is contrary to the tranquility of the community, that employee does not own a unit there. That employee is not an employee of the association anymore. That employee has no right to be there. And you do have the right to say to that employee and to the owners who want to invite that employee to the property, this person cannot come on the property. With that, Jamie, since we're just about out of time, I want to ask if you have any final thoughts you want to share.
Yeah, I mean, I think the main thing from my world is if you have a question or you're unsure about anything, it makes sense to phone a friend. I think the worst thing that somebody can do is think they're doing the right thing and think maybe because it's employment, it should be obvious what the answer is, but it's not always so. Sometimes you make decisions that, have a ripple effect. And so you got to be careful of that. And the other point is, just because it may not be something fun to do, doesn't mean you shouldn't do it. You should use the tools if you're an employer that you have at your disposal. You have contracts to protect you, employee manuals, separation agreements. If there's something that just feels a little icky about the termination, well, maybe I offer them something in exchange for a release. So at least I have peace of mind, because those sorts of things become, the things that haunt you later on. So you want to make sure you do it right, and you do it right the first time.
Well, and I want to, as a final thought, basically echo that point, which is that employment decisions, especially adverse employment decisions, are fraught with risk for the employer. That's the world we live in. And frankly, the employees are entitled to be treated a certain way and protected from certain unsavory or unacceptable comments, or being fired for reasons that are discriminatory or unfair. Jamie has been with the firm for longer than she'd probably care for me to mention. But I have referred many clients to her to assist them with employee contracts, with severance agreements, or walking them through a termination to make sure it's done right. And she knows what she's doing, and she can keep you out of trouble. And it's always better to ask before rather than try to fix something you've done wrong after. And with that, I want to thank everyone for attending. I hope that you found the webinar to be enlightening and informational. And if you have employment issues, to again echo Jamie's comments, ask for help.
Thanks, Ken.
Thank you, everybody. Have a good day.